come back to one of our leading stories now. The Pretoria High Court has ordered the Minister of Trade, Industry and Competition to name the winner of the 4th National Lottery Licence by May the 28th and to finalise a licence agreement by the same date. Now, the court has also ruled that the Minister's decision to extend the bid validity beyond 12 months was unlawful. Now, the urgent court challenge was brought by one of the bidders, Winanjalo, in March. To discuss the implications of this now, we're joined by the chairperson of the National Lotteries Commission Board, Professor Barney Pityana. Prof, good evening to you and thank you once again for your time. I know we spoke a little earlier this week. Here's a court decision that has come now and it compels the minister to make an announcement on the winner of the new lottery operator by the 28th of May. The reason I'm starting with this question is that the minister sounded as unsure whether he would make this announcement by the 28th of May. Do you think that he has any other option but to make this announcement on the 28th?
Well, good evening. Good evening to your listeners. Thank you very much for having us. The judgment of the High Court came through yesterday, and we have had an opportunity to study the judgment. And in many respects, it didn't come as a total surprise because the issues were really very, very finely balanced. And so one way or another, we feel that it's not entirely surprising. The key issue for us is that the judge, in presenting a scenario whereby damage can be limited, has allowed a temporary license for 5 months. And the judge has clearly said that she understands the need for there to be a temporary license. But then she goes on to say that she thinks that it doesn't need to be 12 months, it can be done in 5 months. We are contesting that because we think that the judge just probably misunderstood the scope of what it takes to actually set up a process from the beginning.
Yeah.
Secondly, the judge has said that the validity period was invalid. In fact, he set aside the RFP for the temporary license, and at the same time, he's allowed the continuation of the temporary license for 5 months. But in addition to that, the judge has then told us the validity period that we had extended because, truly speaking, from the 1st of June, all the applications that we've received would fall away.
Yeah.
Because the validity period that we have is up to the 31st of May. Strictly speaking, if we go along with what the judge says, that everything that is done will simply fall away. The good news is that the minister expects to be able to make and finalize the license for the operation of a lottery by the 28th of May, and she also expects to finalize the operation of the temporary license. But there is a barrier in the 5 months in particular that the judge has given us and for which we are appealing the judgment because in the way in which the judgment is formulated, it makes it well nigh impossible to do even that which the judge himself felt was in the public interest to do.
Yeah.
We can't do it in 5 months, and at the very least, it can be done in 12 months. So the judgment is up for appeal. The board has resolved to appeal the judgment because the way it is an impossible judgment to execute, even that which the judge sought to help us to do.
Well, based on what you've just explained, Professor, it means that we're likely looking at a protracted legal action here? Because I foresee Winanjalo not taking this lying down, given that they were the applicants who took this matter to court. We'll come back to that in a second. The minister, in his explanation for why this process of awarding a license was taking a little longer than usual, his explanation, based on an article in Ground Up, his explanation was that, one, the whole process of the award of a license was, quote unquote, extremely complex. And he goes on to say, in the past, serious allegations of corruption were made in respect of the National Lotteries Commission and the way the lottery was managed. These considerations prompted me to take a very cautious approach, he said. Do you believe that indeed what is hobbling the minister from taking decisive steps to a point where it's even led to the courts?
The simple answer, Oli, is that we do not know. And that's exactly what the judge says, that the minister did not disclose, not to the board, did not disclose to the applicants, and did not disclose to the litigants. So the truth of the matter is that the reason that the minister delayed the making the decision is not actually available. So for that reason, the judge has declared the minister's inability to make the decision to be unlawful and unconstitutional. And so that is water under the bridge. Whether the minister is going to appeal on that ground, we are yet to know. But the board has decided to appeal on the grounds of practicality, that practically we would not be able to do even that which the judge has considered is important and needs to be done in the public interest.
Yeah.
And that is the reason why we want to appeal the judgment.
Is it fair, though, Professor, that this temporary license goes to the sister company of Ituba Holdings? Because the company that is understood to likely run the temporary license is called Ituba Lottery. And the understanding is that it is a subsidiary of Ituba Holdings. Is that a fair way of running matters?
The fact of the matter is that if you put yourself in the shoes of the minister and indeed on the shoes of the board of the National Lotteries Commission, there is nothing else you can do. The judge concedes that in the structuring of the RFP, request for proposals, there is no indication that any particular applicant was being favored. That much the judge concedes. Secondly, having considered that, the judge says actually the reasons why the incumbent, with whoever the incumbent makes arrangements with, is in a preferential position is not a matter that could have been foreseen by us, because the applications were open to all 8 applicants, and only one of them actually applied, and for that reason applied as a new company, even not the one that initially applied in the 4th license. Now, all of them had a chance, and we have no way of controlling that. On the face of it, the RFP is normal and fair and makes no preference for another. The judge says that in reality, the time frame within which the turnaround had to be done could only favor, which is really the argument of Winanjalo, could only favor the incumbent. And the point we are making is that that may well be the case, but it is not something that was inherent in the decision that was made.
Finally, Professor, let's talk about the process. Well, not really the process, but the bidders themselves. Are you worried at all that we are going to have a challenge when it comes to politically exposed persons who may be part of one bid or the other, because these are very contentious matters and the rules seem to be very clear here, and that is that people who either hold political office or may be politically exposed persons in one way or the other, they're not allowed to take part in this bidding process. Where are things there? Are you completely certain that the minister will not make a mistake of appointing such?
Well, you know, that would not be a strange phenomenon, because every transition from the incumbent to a new operator of the national lottery has always been challenged. Whether it was between Utingo and Gidani, whether it's between Gidani and Ituba, and this is the third time where this happens. So in a sense, we will be foolish not to anticipate the challenge. But I can say, on behalf of the board, that every care was taken to make sure that everything was done very, very clearly according to law, and that the questions of politically exposed person was examined legally, and we sought opinions where we received opinions. The minister, in turn, also had his own legal advisors. They did their own tests and checks, and they satisfied themselves that whatever decision the minister makes would have been checked and assured in every possible way. Now, nobody can say that there can be no challenge, because in our constitutional state, it's the right of everybody who has an issue to approach the courts, and we can't do anything about that. All we can say, any challenge will be resisted as vigorously as we can, and I'm sure the minister will do the same.
Professor Barney Pityana, thank you very much for your time tonight.